Hello everybody. I'm going to be moderating our panel discussions. So I'd like to welcome to the stage Gillian Williams, John Chesterman and Lucy Adams, please. And just while they're coming up, I'll just introduce myself. My name is Eva Siffis. I am an artist, advocate, author and developer and director of By Accident, which is a series of trainings for other people that have had an acquired brain injury. I personally am passionate about peer involvement at the foundation of any development that happens. Okay, so I'll just briefly introduce the participants, and then I'll hand them over to them to further expand on their introductions. We have, for consumer law, we've got the...
It's Barbora, not John.
Okay. Okay, Barbora. I'll give them over to them and they can introduce themselves. So should we do that? There you are.
Hello, my name is Barbora Ježek. So I'm a lawyer at Consumer Action Law Centre. We're a community legal centre that does consumer and credit law. So historically we haven't had a lot of intersection with disability groups and advocates because it's been sort of government area, but I guess now with the NDIS we're seeing more of that intersection, so it's an area we're looking at as well. And yeah, at the Consumer Action Law Centre I'm sort of leading the NDIS project, which is probably sounds a bit grander than it is, but it's basically just to make sure that disability advocates know that we exist so that they have sort of another tool in their toolkit when looking at issues with participants' plans.
Great.
I'm Lucy Adams. I'm the Manager of Strategic Advocacy and Policy in the Civil Justice team at Victoria Legal Aid. So I can see lots of my colleagues in the room, and I should say by way of opening, I'm not on the tools anymore, so I'm not batting up in court or in the tribunal like lots of you in the room are, but my role is working with the advocates and lawyers on the front line and spotting systemic issues and listening to what we're hearing through our clients and consumers, and then advocating for positive change. And that is, of course, what many of you will know, brought the NDIS onto our radar, and it's a big reform priority for Victoria Legal Aid. In the last financial year, we assisted nearly 96,000 Victorians and 22,000 people identified as having a disability or experiencing a mental health issue. So we realised quite early on in the transition to the NDIS that the NDIS was inextricably interwoven in the lives of our clients, and that we didn't just see it through the lens of the appeals work that we're funded to do, but actually it was popping up in unexpected places. So we were seeing clients who were entering the justice system and unable to exit, spending protracted periods in mental health units, unable to maintain care or custody of their kids, and that's because they weren't getting the supports and services that they could have been or should have been under the NDIS. So there were, I guess, the NDIS and the legal work that we're doing across legal aid are interwoven, and we've got a project across the whole organisation, which is quite rare because we often function in our separate silos, but it is focused on the advocacy component and positive change, but also on training and capacity building within legal aid, and then identifying some of those escalation and referral pathways for the lawyers, the 500 or so lawyers who are working across Victoria, so that they know how to spot and respond to NDIS issues as well as they can. Great.
John Chesterman, I'm the Deputy Public Advocate at the Office of the Public Advocate. So we're the adult guardian of last resort in Victoria. We're also host of 4 volunteer programs with upwards of 600 volunteers who in those various programs work to promote and protect the rights of people with disabilities. We also have a systemic advocacy function, and I'll talk a bit during this presentation this afternoon about some of the work that we've done there in systemic advocacy. The one point I'd make at the outset is that some of our guardianship clients are NDIS participants with the most complex needs amongst participants in Victoria, and so we do see a particular failing or difficulty confronting the NDIS when it comes to people with very complex needs, and I can perhaps talk about that a bit later on.
Okay, well, I'll just go straight to the first question then. Given the autonomy that comes with having an NDIS plan, what type of issues have you seen arise in your practice as a result of the rollout?
I guess the things that we're seeing, so because we're a community legal centre, I suppose we get people who request legal advice, whether it's from community workers or the public generally. And we haven't had the sort of maybe influx that we were expecting for NDIS issues, and a lot of that I think is because there's kind of a range of different issues in the space that maybe the consumer parts are not maybe front of mind at that point. But the sort of things that we've been hearing are issues to do with, I guess, people having to negotiate a contract for the first time, for example. So they've got the autonomy, but that also presents some problems for people for many who haven't had to deal with such kind of complicated legal contracts and having to negotiate them. And they're, not easy things to do. And if it's a lot of participants haven't really had to do that. And obviously some are lucky enough to have advocates who help them through that process, but it does prevent that extra, where there's autonomy, it also means that there's that sort of, I guess, the opposite problem of you're there on your own in a way to manage that system. So that's probably the main one in terms of autonomy. And I think the reason, from our experience, what's happened in the past when there's been a new market created that has an injection of government money is we've seen kind of maybe not so savoury businesses enter the market to take advantage of that. So that's obviously a potential issue. We've seen it in the past with private colleges and things like that when there was vet fee help. There was a big controversy with that, even things like sole rebates. So whenever there's sort of a big influx of government money and you've got a lot of people that more access to money and getting their own services, you've got a lot more people vying for that money. So yeah, we see that as one of the things that we need to look out for, and we hope that there'll be enough protections, but that's something that, in terms of autonomy is a problem.
Of course. Would you like to contribute?
So one of the things that we're seeing, and John has touched on it and Bruce did earlier as well, is that for people who aren't as well placed to navigate the complex system, they're just not getting the benefits of choice and control that the NDIS promises. And this can be particularly the case for people interacting with multiple different service systems. And what we see a lot of is people who also have justice system interaction. And so I'm sure a lot of you in the room saw the report from the Victorian Ombudsman late last year on Rebecca's case. And she was a woman with disability who ended up spending 18 months in prison, a lot of it in solitary confinement, and a lot when she was cuffed and had really limited interaction and time outside. And the Ombudsman observed that while the NDIS has such huge potential and is a source of optimism and could potentially and did step in to meet the needs, at that time it was adding a layer of complexity and probably creating more gaps than it was filling in some of those complex cases. There also, because of the nature and the devolved nature of the NDIS, there aren't always clear lines of responsibility. So there is a greater risk that people can fall through the gaps. And so in that context, we are seeing the really critical role for support coordinators and specialist support coordinators to be the glue.
Sure.
Yeah, sure. So, and just touching on that topic too, so one of our observations would be that people with particularly complex support needs haven't been well served at the moment by the scheme. So I define people with complex needs, and touching on what Lucy said, people with complex needs would be people who have multiple and or severe disabilities requiring various forms of support, often compounded by an experience of trauma. Also, people who experience problems with interpersonal engagement, so that they have limited family support and sometimes are unable to live with other people. People in that category have found it very difficult to get adequate support through the scheme. people whose behaviours or situations put themselves and or others at risk have found it difficult to access appropriate supports in the scheme. People who've had a history of involvement with other service systems and or of homelessness also found it very difficult. So as who mentioned it before, but OPA produced, I know Bruce talked about another report I'll talk about later on, but OPA produced a report late last year, September last year, called The Illusion of Choice and Control, where we identified 11 case studies of people with complex support needs and made a number of recommendations as to how the scheme might better work for those people. And I would say in kind of praising the NDIA, that the NDIA, when it came to the production of that report, and indeed in the time afterwards, when it comes to people who are with extremely complex support needs, in the end we have been able to work out suitable arrangements for many of those people through high-level support from the agency, but it's come right at the end of the process after a lot of advocacy. And I can look around the room and I can see a number of advocates in the room who have had involvement with one or more of the people who we've supported and who are referenced in those case studies, who would know what I'm talking about. That what we want to see is much earlier intervention and systems talking to one another, particularly the justice, health, mental health systems talking to one another, so we don't see the kind of scenarios that we saw in the Ombudsman's report or that we referred to in our report, where, for instance, we've had people who are even sometimes in mental health facilities for no particular therapeutic reason other than there's no other accommodation setting in which the person can be safe.
For sure.
The other area which I would talk about, and probably it's a bit kind of particular to our area, although it will resonate, I think. Of course, with the arrival of the scheme and the signature element of the scheme, which appropriately is consumer choice, we had a fear right at the start as to what would happen when people were unable themselves to make choices without support and or had no other supporters around them. So what would happen? Suddenly we have more decisions to be made. Who would be making those decisions if the person themselves could not? So we feared a rush on guardianship applications and we feared a rush on the use of plan nominees through the federal scheme. Now, there wasn't that rush so much in Victoria. There were troubling developments elsewhere, but this is something that we need to be constantly vigilant about. People know that the Convention on the Rights of Persons with Disabilities tells us, at the very least, that we should be having as few guardianship appointments as possible, and that we certainly shouldn't be having guardianship appointments for reasons of what I would call administrative efficiency in order for someone to be signing a piece of paper, whether it's a service agreement, an access request form, whatever. We shouldn't be having guardianship appointments simply to enable unproblematic administrative steps to be taken. So we've been in fact saying this now since 2014 was the origin of a guide that we have on this topic called A Guide to NDIS Decision Making, where in this guide, and we've got a flowchart, we work through the complexities that exist in this area because we have state and federal laws that govern guardianship, enduring powers of attorney, compulsory mental health treatment, and federally we've got plan nominees. How do you work your way through all that? Bearing in mind, of course, one of the key elements of the Convention on the Rights of Persons with Disabilities, and what is ground level for all of us, is that people should be supported to make their own decisions. And how can we do that? So that's another area that we've had concerns about.
Yeah. Okay, next question. Given that the NDIS relies on services being provided by private providers, what are some of the issues that you have encountered, and what are some of the ways that the participant rights to be being upheld?
Yeah, so I think from a consumer law perspective, I guess the main areas are all the different consumer law areas that people haven't had to deal with before. So, when you get an equipment or any sort of service, there's all the standard sort of consumer law guarantees, just like when you buy a TV or a car or anything, that actually now apply to disability services and products. And a lot of participants aren't actually used to thinking of these services and products as things that they can complain about or that they have to fulfil certain requirements. So I think people even being aware of that is a good first step. But once you are aware of that, there's obviously still a process of how you go about that, and whether service agreement providers are also aware of that. We're hoping that there's certainly, I think, a role for that to be more common knowledge, because I don't know if service providers are aware of their consumer law rights and the sort of things they have to be doing in terms of responding to complaints and, you know, when people are entitled to refunds and repairs and all those sort of things. But certainly the most common ones I've sort of heard about would be in service agreements and those sort of different terms that are in there. We've heard about, you know, very difficult cancellation clauses, like having quite high penalties or having to give like 6 months notice, things like that, you know, just like any other contract can be disputed. You know, you could argue it's an unfair contract term, things like that, but they're not necessarily easy solutions and they're not always quick. So when you've got these sort of, you know, yearly plans, that can be a problem. But in terms of, I guess, how to actually uphold people's rights, we haven't had a lot of test cases in VCAT, in the tribunal that deals with these sort of civil claims. So we have yet to see how a tribunal member that's not familiar with the NDIS, how they'd get their head around it, because it's not an easy system to understand and it's not a simple contract, especially, we know, when you're talking about different pricing ratios and how they're supposed to apply and you know, how the plan works in the background and all those sort of things. So that's something that has yet to be tested because it's sort of only just been rolled out and we haven't had those cases go there yet. So we'll have more information when that sort of happens. And then the other new one will be the Quality and Safeguards Commission, which I'm really curious to see what sort of things the Commission looks at. So I'm looking forward to the next panel as well. But, you know, in terms of what does quality and safeguards mean, does that include consumer law rights? Does that follow consumer law in terms of how that's applied, or is there a kind of more informal system? All those sort of things are to be seen. So, you know, at this stage, I think it's all being tested at this point. We kind of know the theory, but we haven't seen a lot of it actually come through to fruition and see how it pans out.
Are there plans to educate the market on what they need to do and their rights, and maybe provide them in easy English so that participants can educate themselves on?
Yeah, it's a good question. I suppose as everyone's limited by resources, so we're a specialist legal centre that's consumer law. We're the only one that sort of specialises in that. I know the ACCC, which is a federal regulator, has done some simple consumer law fact sheets about that. I know that in New South Wales, Consumer Affairs are out there with the community. I'm not familiar with Consumer Affairs Victoria doing the same thing. So I guess everyone's sort of doing little bits and pieces, but I'm not aware of like a very big, I think it's very state-based and piecemeal. So it's hard to know. I think, you know, we're sort of starting just trying to get the word out to advocates because they're the ones who have access to lots of participants, so it's kind of a good way of doing it, but obviously that's not going to reach everyone.
Baby steps, hey what?
Yeah.
And you, my friend?
So I think probably the most significant thing that we're seeing impacting on our clients is thin markets and market failure. So where people have kind of well-informed plans that do have the potential to meet their needs, to live well in the community, but the market isn't yet ready, willing or able to step in and meet those needs. And it is a crew of clients that John was talking about earlier, often people with more complex needs, or people, of course, in regional areas. And we got together with Legal Aid Queensland and Northern Territory Legal Aid Commission to do a joint contribution to the Thin Markets project that DSS, NDIA and Ernst & Young are running at the moment. And similar to the approach OPA took, we looked at, we spoke with 10 people who were willing to share their stories, because one of the things we observed is that thin markets and market failure, while all of us in the room know what it means, they're quite euphemistic terms and they don't really convey what that means or what that looks like for someone when the market does fail, and what it means for them and their families and the community around them. So we worked with 10 people and they shared their stories, and there were just, I guess, themes that aren't surprising but that emerged. So 7 of the people were in regional and rural areas, 6 were young people, 2 were homeless or at risk of homelessness, and 4 people had spent prolonged periods in prison or in a mental inpatient unit, mental health unit, that could have been avoided if the right housing and supports were available in the community. So I think with lots of people in the room, one of the big things that we continue to stand by as being needed is a service safety net. So it was previously, I think, referred to in some of the planning documents and advocacy as a provider of last resort, but it's a systematised guarantee that people will be able to get the services that they're funded to receive, because the consequences of people not being able to do so are just so significant for their immediate and long-term well-being.
Okay.
Yeah, and ditto on thin markets, and this is the need for market stewardship here. Bruce is point 6 on his top 10 points, and I'm really looking to Bruce, as I'm sure we all are, to because he has the credibility, of course, in this area, and as the one of the key architect of the scheme. We are hopeful that Bruce's observations here about the limitations of the Productivity Commission report and the subsequent rollout of the scheme is such that this really jeopardises the significance of the scheme for people, particularly with complex needs. And I can just think of we have our work, and we also have our lives outside of work. I was at a family function the other day. There were 17 people in the room, 2 of whom are NDIS participants, and both of them have underutilised plans. They've both got plans that are underutilised. One is my nephew. My brother is one of the most articulate people in the country, and he can't get adequate services for his 16-year-old son, my godson. And it's kind of gobsmacking because the money's there, but he just can't get, there aren't services that are appropriate for this young man. If I look at the people for whom we are guardian, we are seeing instances, of course, when we talk about choice and control, we're also talking about choice and control of service providers who can choose not to provide services. And so we are in this situation now we've never been in before, where you can be advised that a service provider is withdrawing from providing service for a highly vulnerable person. And so that raises all kinds of concerns. I remember flagging this, and this is not a new topic, and Bruce, I know, has been talking about this for many years. I remember flagging with a senior NDIA person, what would they do in situations where there are no adequate services? And the response there was a kind of belief in the market that, well, we'll just keep paying a higher amount until we get a service provider who will be willing to provide the service. And I can see smiles around the room because this is not how it's played out, of course. So thin market's one area. Bruce touched on the other area I'll talk about, which is another kind of market mechanism, which is the bizarre thing called the service agreement. So, as Bruce said, we produced a report on service agreements in June this year. I should say all of the reports, I'm holding up these reports that none of you can see, just as proof to those on the panel that I know what I'm talking about. But I can talk afterwards, and I can see Sophia is here. Sophia, wave your hand from the Office of the Public Advocate at the back. She can also tell you about what these reports are. They're all on our website, but I can, Sophia and I can point you to them later on if you would like us to do so. But in that report, we identified some of the kind of strange practices that have gone on, and of course, you know, we can talk as lawyers about the bizarre nature of service agreements because the agency is paying, but the agreement's between the participant and the provider. So you have what's legally a third-party beneficiary. But what does it actually mean, though? And in our view, and I know Bruce's, and I think Bruce's and others, is the agency should just take greater control, regulatory control here. They are footing the bill. We, Australian taxpayers, are footing the bill. So why aren't there tighter controls over what can be done in service agreements? But we've seen, and we put in our report, some strange practices, including things like anti-competitive provisions, inappropriate assignment of rights, unreasonable expectations on participants, inadequate description of services, improper signing. We had for many years on the agency's website a statement that service agreements could be signed by family members on behalf of a person. Now, family members don't necessarily have any legal authority to sign an agreement on behalf of a family member when we're talking about an adult participant, and yet that was on the website for a long period of time. So the agency's kind of trying to move between facilitating the market and not requiring undue formality, but it's come out in this bizarre kind of amalgam in what is the kind of service agreement arena. So we, as a guardian, will sign service agreements, but we can only sign agreements that are within our power, and so we have to put in particular limitations around what we can sign. And in fact, we've now, in a bid to help service providers, we've got on our website a pro forma that they can work up to suit the needs of the particular participant. But in our report, we also made an argument that sometimes there will be a need for services to be provided without a signed service agreement. The other point to make also, and is one which Eva's touched on, is, of course, in this area, if we're to have meaningful descriptions of services, and if we really want to ensure that the participants, know what they're receiving, then we have to have easy English versions of service agreements. And this has been a long time, I know they're appearing now, this has been a long time coming. And so this is, a key incident of the Convention on the Rights of Persons with Disabilities, that people should be involved and make decisions that affect them. So surely the use of easy English is paramount when it comes to service agreement. I'll stop there.
Okay, next question and last question. This is to do with gaps in markets for services. What are some of the challenges that everyday participants face in accessing services? What are some of the ways that these gaps can be overcome from a systematic point of view? Would you like to go first?
I might let Lucy go first.
Markets. We've got a particular cohort of people, I guess, who we're particularly interested in the gap, which is for people in prison. And there seems to be, I guess, an inconsistent approach across the country in terms of who is playing different roles and whose role it is. We know in Victoria in particular, people are spending very short periods in prison and kind of an unpredictable amount of time in prison. So really, people with disability, we kind of need to be on the front foot early. We can't be waiting to 6 weeks pre-release. Because if people don't have access to the planning process and don't have the supports in place, it is jeopardising their ability to exit, and it does mean that people are in prison longer than they should be. It also means that when people do exit, if they don't have the right supports in place, there is a greater risk of reoffending and re-entry.
Yes.
And in Rebecca's case that I mentioned earlier, she cycled in and out of prison and homelessness, I think it was 5 times in the preceding 9 months, before she ended up being then in prison for that 18-month period. So I think as a system, we do need to be doing better at, A, preventing people with disability entering the prison system at the rate that they are, but B, identifying who is in prison with a disability and what it is that's, I guess, precluding them their release and their successful, sustainable long-term release, because they've got the supports they need in the community. So I think that is an area that I know a lot of thought is currently going into, that interface between NDIA and justice and the state role as well. But we are seeing day to day that we're not there yet, and that is having a real impact on people.
Yeah, a project that I'm an intrinsic part of is a voice at the table, and at the moment now a new side project is being brought on, which is Voices for Justice, and hearing you speak about that, that's the alarm bell that's going off in my head. You need to hear from the actual people and not just talk for them. And that's what Voices for Justice does, is actually give the participants the ability to speak for themselves. Would you like to say anything?
Sure. So access to adequate services would be the key area. For us at the Office of the Public Advocate, we identify, of course, people with particularly complex support needs, specialist disability accommodation, short-term accommodation and assistance, what used to be called respite, and psychosocial disability supports. Those areas are the key ones where we think there needs to be market encouragement and facilitation. We, in terms of kind of systemic work to address those gaps, we'd say a few things. We've called for a while now for there to be what we've termed and others have termed a provider of last resort, so someone who could be basically obliged to provide services. That could be one provider, could be a panel of providers, but someone who there's too many examples of market failure for us to ignore this problem, and there needs to be that lever. On that topic, Bruce can say more eloquently than me about the need for market stewardship and the facilitation of the market to ensure adequate service provision throughout the country, because we're talking about one of the best resourced jurisdictions in terms of service providers here in Victoria. You can imagine what's like getting adequate services in Katherine and other parts of the country. Contingency funding for crises is another area that we would identify. And we'd also talk about, kind of touching on Lucy's point, the need for all services that interact with people with disability in places of detention, particularly prisons, mental health services, also in hospitals. We need to have protocols and interagency relationships whereby people can ensure that they become or participants in the scheme, or indeed have full utilisation of their plans in those service sectors, so that there can be a smooth transition out, because we are seeing people stuck in prison, in mental health facilities and in hospitals without adequate utilisation of their NDIS potential. So I'd say that as well. There was another point, but it's escaped me. That's all right, we can come back to it.
Okay, well, I'll go on to my personal question, which is, of course, how have you involved peers in the development of your policies and the work that you're doing?
Yeah, so I guess our work is basically to meet with disability advocates and to find out from their experience what they've been seeing. So that's how we've basically involved it, because we are, it hasn't been a core part of consumer law previously, so it's really just meeting and working out, each kind of region has its own particular issues, and different disability organisations will have different experiences. So that's been our main source of information, and it's definitely a wealth of knowledge. So you'd get a very wide and concise picture of society at the helm of your work. It'd be quite a privileged position to be in. And you, how have you involved peers?
So through the views of clients and consumers, kind of that we're directly interacting with through our work. But we've also got two advisory groups with people with lived experience who are experts in the mental health system and the child protection system. And both of those expert advisory groups are headed up by staff members who themselves have lived experience. So those groups are crucial to advising the organisation both on our service provision, but also on our advocacy as well. And then specifically in relation to NDIS, we did have an ILC grant and worked, the IMA of Victoria Legal Aid, so the Independent Mental Health Advocacy Service, the non-legal advocates, worked with Tandem and VIMIAC and DHHS to co-design a self-advocacy module in relation to the NDIS, specifically focused on mental health. So I'm sure lots of you have seen it, but if you haven't, I commend it to you. It's a pretty amazing resource to help people identify what their own rights are and speak up and self-advocate.
I think we might have been lucky with an ILC grant. That's Brain Injury Matters, United Brains, and By Accident too, which is very exciting, finally. Doctor?
Yes, what I'm talking about today has mainly arisen through our role as guardian of last resort, where we're appointed by VCAT. In exercising that guardianship role, we're required to take into account the wishes of the person for whom we are guardian. And people will know that from 1st of March next year, our guardianship law has changed, 179 days away. And from then, guardians, whether it's us as the public guardian or private guardians, will be required to make decisions that the person would have made themselves. So that's a significant human rights change that brings us much more in line with the Convention on the Rights of Persons with Disabilities. So that will be, it's quite a significant change that we will be much more an agent of people rather than just being required to take into account someone's wishes. We'll actually be required to do what the person would likely have done themselves.
Yes, exactly.
So that's a significant change.
So that means actually corresponding and working with the person on what they want.
Yes, I mean, we like to think we do it anyway, but in fact we can think of scenarios now where our decision would probably change slightly as a result of that new requirement.
I can remember my time under the Guardian, and I would hope that things would change these days.
It's a needed change.
It's been a long time coming, obviously.
It has been a very long time. 1986 were our laws, which this element hasn't significantly changed.
Well, it's about time. Okay, I think we'll take it out, send it out to questions now. I'll ask that everybody waits for the microphone before saying your question so that it can be recorded. Okay, over there.
Hi, my name is Barbora and I'm a family advocate for my beautiful little daughter who's 18 months old. I just had a question about variability and service agreements. Because she is so young and she currently has the only one in the world with the genetic deletion she has, it's very difficult for me to predict what service she will require, what hours will be required. So I realistically don't know in 6 months' time what she'll need. And so how do I create a service agreement in cases where the disability isn't a stable, fixed situation? Like, how do you create that when things will fluctuate?
I'm looking around all the experts in the room and thinking there's going to be, on occasion, people in the room who are far better placed to answer the question than us. That's okay. But feel free
if there are people in the if there are people in the room,
if there are people who would like to answer that. But I mean, I think it's key that the service be adequate and appropriate, and so any agreement has to build in that flexibility to ensure that you have some lead-in time to work out what's going. An interim agreement, for instance, for a short period of time to work out what's going to be required longer term, and then when you are reasonably confident at the level of service and that's in the package, then you can have a longer term agreement. But I'd be very reluctant to be signing anything that, in a sense, signs you up to a longer term inappropriate delivery of services. And yes, and I'm interested to hear if others have thoughts on that topic, because it's not an unusual topic.
Good afternoon. My name is Chris Carl, and I'm on the next panel. I'm a representative from the National Disability Insurance Agency, and this is a perfect case where hopefully there'd be great support from our early childhood, early intervention partner delivering services and working with you, so that there's that support to build the flexibility into the plan. And the plan might be for a shorter amount of time because life changes a lot in those early childhood years. And then the terms of that plan, and there's always, with supports that people have committed to, that there's always, within a service agreement, we hope, the ability to change providers or change services or arrangement around how you'll stop receiving a service at a particular time.
Reply.
Sorry, I'll be very quick, you poor people. So I will just say, from the interaction you have with Link, who's the early intervention partner, so some examples, for example, when I called, I got told my accessibility meeting would be in 6 months. Just the accessibility meeting. I then got a missed phone call on my phone, so I called back for about 2 months, only to be informed at the end of 2 months, after calling probably every second day, that the planner in question had left the organisation and my messages were now effectively going into the ether. I then got another planner who was so junior, whose last role was as a barista.
Wow.
Perfectly nice, but just deeply inappropriate. Who's then was with her manager because she was so junior, but she then undertook the 2 days of training that was required for her to write a plan. So at the next session, 6 weeks later, where we did the plan, she was actually now so senior, she was training someone. And then they also did during this, they also did a PEDS-DM assessment, which is a proper therapeutical assessment, which technically should only be done by allied health or with an allied health person. During that process, I didn't even know that this thing was done on a scale, on a Likert scale. I thought it was a yes-no binary response because the person didn't tell me. And then also the person, when I asked questions, said, look, I'm sorry, I don't understand what that question is. The person didn't actually know because they're just reading straight off an iPad. They literally have no idea. So yes, that was my highly experienced early childhood partner, and I'll let someone else ask questions now.
Worrying.
So if I can just add, just to say that I'd be very happy to talk more and talk together with Link Health and Community about that situation, those circumstances, because in the main, the early childhood partners staff are early childhood educators or allied health professionals who've been employed to share and work with families in the home setting in a natural environment, so they're able to observe and support the family. And I imagine many people are aware of the early childhood remediation activity that's going on currently to resolve wait times for access to services, and they are rolling out quickly to try to ensure that all families with a young child are able to receive support to some level.
Okay, are there any other questions?
Just a quick one. John, you mentioned the provider of last resort issue. You're obviously at the sharp end of some of those cases where that's required. What's your experience been of how that's evolved? As far as I know, there's no sort of established pattern for that yet, but it's very much a case-by-case basis. I'm just wondering what you're seeing is happening in that space.
Yes, it still remains case-by-case. I understand there are some developments occurring that will be subject to be announced not too far away, but I'm not privy to the details. But I do know, one of the things that has occurred in the area of concerning participants with very complex needs is, of course, the complex support needs pathway that David Coyne at the NDIA has been leading, and that's been in a number of instances for us that has worked very well for our guardianship clients. But we're talking about a handful of cases here of people with the most complex support needs where we've suddenly got specialist planners involved who have extensive disability background and have been able to get together service providers and cobble together, appropriate services to support a participant in a way that, amongst other things, as well as fulfilling the human rights of the participant, actually saves money in the end. If you look at money saved on, for instance, a year in prison, what does that cost? $100,000. It's much more sensible economically to provide adequate support. So we have seen with complex support needs pathway some good outcomes. The problem there, of course, has been, as happens in this area, once you see something good happening, everyone swarms into it, and the people in that network have been very nervous about being swamped with people, and of course, once you're swamped, you get waiting, you get queues, you get not good outcomes. So it's still a work in progress.
This is a question for you, John, and also you, Barbara. In relation to the OPA investigation into unfair contracts and service provider agreements, in your report and your investigation, you found that there were some cases where, despite the fact that your guardians refused to sign agreements which were clearly unfair, the participants ended up getting the services delivered anyway because there was no requirement for them to be signed. And secondly, they would go back to the participants and say, well, do you want us to deliver it? And they say yes. And so they because there's no requirement, they just went ahead and delivered it anyway. What's your solution to that? What sort of powers do you have under OPA to get around that? And yours, Barb, in terms of consumer law, how does that intersect with the power of a guardian to refuse to sign something which is unconscionable, and then the service provider just goes ahead and does it anyway and doesn't require a signature. Where do those two fit?
Yeah, it's a good question, Trevor. It's not easily answered. I mean, we always, when we have a situation like this where, for instance, there are unfair clauses in a proposed agreement, we won't sign it on that basis, or we'll be asked to sign things, for instance, that say that the participant will treat the service provider with respect. Now, we can't sign that on behalf of, it's just beyond our power to sign something like that. Anyway, if we then negotiate and don't get a satisfactory outcome, what always drives us is the interests of the person for whom we are guardian. So we will have to make a decision in each case what what suits at the moment, what's in the best interests of the participant, and down the track, on the 1st of March next year, what would the person have wanted us to do? That guides us. So sometimes it will mean consenting to the provision of services without a signed agreement. And in fact, one of our recommendations in that report is that sometimes services do need to be provided without a signed agreement. We certainly don't want to see the bizarre situation where you get a guardian appointed in order to sign a service agreement, which would be, none of us would be suggesting should happen, but still is a possibility. But in terms of reform, I mean, it actually gets to the curious legal nature of service agreements in any case. No one objects to the idea that, okay, someone's going to be providing services, you want to know what those services are and what your entitlements are, that's fine, but that can be done in an easy English sheet that could be handed to someone. You don't necessarily have to enter into a kind of a signed agreement scenario. So in short, what we would like to see is the agency to take greater control of this area, have requirements around unfair elements of unfair clauses in agreements. As Bruce was saying earlier, potentially make those illegal, which in some ways they are anyway when you get to anti-competitive practices and so on, but provide more guidance on what needs to happen in order for a service to be provided. Sometimes it will make sense for a person to themselves sign something because it does give some degree of formality to the arrangement, but not in every case.
I guess from a consumer law perspective, it's an interesting point. I think, like you say, I mean, unfair contract term is a funny area because it's, a term won't be considered unfair until a decision maker has decided it's unfair. So it's sort of always at the end, unless the NDIS puts a specific list of terms that are considered unfair, you have to challenge them first to get that determination. So even they look unfair, unless someone's actually said so, you can't do that. But in terms of, I guess, agreeing to something, despite the fact that the guardian has not agreed to it based on a number of different reasons, I think you could very easily challenge that from a legal perspective, because if that service provider is aware that person has a guardian making decisions for them and then has gone around it because it didn't get what they wanted and then made a separate agreement with the participant, there's definitely some legal arguments to be made about challenging the whole contract. But I guess that would be on a case-by-case basis in terms of exactly what's happened and why the guardian didn't feel comfortable signing it, all that sort of stuff. But I think that could be very much something you could challenge.
Any more questions? Okay. Yeah.
Just a question for the panel. Given that safe and secure housing is a fundamental human right, what can be done about the 30,000 people living across Australia in private congregate care facilities? They're for-profit services that essentially are quasi-institutions, and they're often kind of, not always, but often kind of very difficult places for people. People can be there's a lot of bullying, there's a lot of kind of implicit violence going on. There's also a lot of exploitation of people by these private congregate care owners. And many stories of kind of like kind of these unholy alliances between private care congregate services and service coordination services, which kind of really pushing the boundaries around kind of like issues of kind of like exploitation of people who are, you know, very vulnerable. And John, I imagine that's something that you're perfectly aware of. But you know, is this state or federal? Is this NDIA? Who's going to come in and kind of like make that change and ensure that people can have access to safe housing?
Yes, look, that's a good question, Neil, and it is something that, of course, Victoria's in the process of closing all our residential institutions, just closing Calander, and for people with disabilities. Of course, it was always going to be a challenge of what if participants chose to live in larger settings. Now, we've engaged with this. The research is incontrovertible and tells us that people fare less well when they're in large settings. Now, one of the, I don't need to tell people in this room, sometimes we've had debates with carers groups who have on occasion argued that it makes more sense for them and for their adult child, family member, adult child with a disability to live with 8, 9, 10 other adult children, adults with disabilities, where the carers have joined forces and said, you know, we should set this up because we can then hire staff, there are economies of scale and so on. We've argued this is not in the interest of the person themselves, and there's a kind of a good-natured debate about who knows best what's in the interest of the person. We point to the research here. The agency was initially a bit unsure what to do with this kind of topic, because it both recognised the research and also said, yes, but it's about choice. And our offering into this debate was always, whose choice are we talking about? Because we're talking about the choice of a carer that's different to the choice of the person. And even if you're putting it out as a choice of a person, how have they been educated about the variety of options that might otherwise be available to them? What I've also said to carers as well is that this may start out as a good thing and it may end up as a very not good thing. So we have to be mindful of that. And because what's driving carers, of course, is concerned what happens when they're not there. And so they want to set things up. So I'm absolutely sympathetic to the motivation here. The agency did put out its guidance that, I'm not sure if this is still available, but it certainly said that no more than 5 people in one setting ought to receive funding through the scheme for housing. Now, I'm presuming that's still out there. I haven't actually seen it in the last couple of years, but that was a policy of the agency. I'm looking around if anyone knows whether that is still the policy, but it's a tension that continues to exist. We would be saying, given the deinstitutionalisation process that began in the 1980s and is only being completed now, it would be bizarre under the name of choice for us to return.
Anyone else from the panel? No? Any more questions? Okay.
This might be a question that you can comment on, Lucy. In relation to the NDIS and breaching human rights obligations, is there any work that's being done in this space? And what do you see are the barriers to keeping the NDIS accountable?
Yep. So, as a lot of you will know, all of you, Victoria is one of the, well now, 3 states and territories to have our own state-based human rights protection. So with the movement to NDIS, that obviously throws that regime up in the air a little bit. Particularly housing is a good example. It was just raised. It was previously provided by a state-based provider and now might be provided by a private provider. The coverage of Victoria's human rights legislation is not clear in the absence of further specification in regulation or legislation. So I do think we're entering probably an uncertain time in terms of legislative protection of human rights at a state level with the movement to the NDIS. I think there is obviously ongoing work being done about the need for a piece of federal human rights legislation, and that is something that I think all of us in the room and so many of the people we work with would benefit from that protection. We're one of the only democratic nations that doesn't have legislative protection of human rights at that national level. We've obviously got our international protections of human rights that are relevant, but it's about the enforceability and how you realise those rights. So I think it is something that we all need to be mindful of how we're bringing human rights to life in this new privatised regime.
The only thing I'd add to that would be, and that absolutely support what Lucy said, it's a powerful advocacy tool, the Convention on the Rights of Persons with Disabilities, and Trevor, I know, looking around at multiple people in the room who frequently utilise it as an advocacy tool, and I encourage you to continue to do so. It is something where Australia has ratified this instrument, and we need to be mindful that that's the way in which international attention is focused on Australia, where we are said to be not compliant with our international obligations. So it's a strong advocacy tool.
Okay, maybe one more question. Okay.
This question is in regards to restrictive practice. So I know that restrictive practices were governed by their own law, but how do organisations now facilitate restrictive practice where clients have cognitive impairments and they don't have choice and control, but in line with the NDIS legislation and the new NDIS Commission?
So restrictive practices, it's now a complex amalgam. Victoria's got one of the strongest histories of restrictive practice regulation in disability services, and to some extent that continues. So states and territories are still required to authorise restrictive practices where there is an authorising regime, which there is in Victoria, and reports are made to the NDIS Quality and Safeguards Commission, where the senior practitioner, Australian senior practitioner, works. So it's the system that kind of more or less continues, but of course the challenge here is it is a system where there are a plethora of new providers who may be less aware of their legislative responsibilities in this field. So that's the area where we're most concerned. It is also, I know Miranda's about to come up, this is not her area, but she's in the commission, at the Commission, and she'll be able to talk about this a bit too. But it is a complex message to be getting out to people how the state-based senior practitioner and our Disability Act requirements in this field relate to the national sphere. But the short story is there's still that authorising requirement under state disability legislation and a reporting requirement to the NDIS Quality and Safeguards Commission. It's different in other jurisdictions.
Do we have one more really quick question or not? Okay.
Deirdre Griffiths from Philamanta Disability Rights Legal Service in Victoria. This might be a question for Barbara or anyone on the panel, just about the registered service providers, and then some people who are self-managing their plans will be sometimes using service providers who are not registered. And could you clarify what the legal basis for complaints to be made? Apparently complaints can be made to the new National Commissioner, but how does that work for providers that are not registered?
If you can try and bring your question, the answer to this question down to 30 seconds, if you're right.
It's a great question. I think it's one we're also waiting to see. The Commission, the website, says that they can do it, that they have a bit of teeth in terms of how they do it and dealing with unregistered providers, but I'm a little less sure as to what, consequences there are for providers who aren't registered. So from how the Commission will manage that, we're yet to see that. I'm not sure.
Miranda's on the next panel and can deal with this as a question on notice.
Excellent. That's great.
let's wait until the next panel because we're out of time. Okay, we're going to have a 15-minute break now. I'd like to thank our panel, and I'm sure you would too.
Thank you very much.